All tariffs likely to share the limelight during that State of the Nation address. Extra attention on whether Supreme Court justices who struck down President Trump's tariff policy would be in attendance.
That tariff turbulence is now prompting countries worldwide to reassess their positions as sealed deals are now in question. It could leave agreements with top trading partners, the EU and India, in limbo. The New Delhi has reportedly delayed trade talks over the new 15% flat tariff, which is 3 percentage points lower than the deal it struck earlier this month.
One senior EU lawmaker called it simply pure tariff chaos, urging the bloc to delay a vote this week to ratify a deal that was on the table. Last July, the EU agreed to remove duties on many U.S. products in return for a 15% U.S. tariff. The EU says the U.S. must honor it, saying a deal is a deal, rejecting any increase in the rate.
Well, last Friday, the U.S. Supreme Court ruled 6-3 that it was unconstitutional for President Trump to bypass Congress and use emergency powers to unilaterally impose tariffs, striking down the slew of Liberation Day levies. That set in motion 2 new tariffs in 2 days as Mr. Trump resorted to trade statutes to prop up his signature policy. First, 10% and then replaced by 15%, effective for 150 days.
The U.S. Trade Chief, Jamieson Greer, says no country has pulled out of any deal so far. China has yet to respond. President Xi Jinping is due to host Mr. Trump for a visit next month. A trade truce is currently keeping the U.S. tariffs on Chinese goods at 10%.
And elsewhere in Asia, Japan, which had an agreement for 15% U.S. tariffs, indicated it will keep its $500 billion investment pledge. Now, Indonesia says it's ready to face all possibilities. It had a deal for 19% tariffs. It's seeking assurances that the 0% concession will remain intact. Malaysia also struck a deal for 19% tariffs. The Prime Minister Anwar Ibrahim says he has heard from his trade minister and the cabinet will be briefed this Friday on the new tariffs ramifications.
Datuk Jo telah bagi penjelasan, kita akan dapat penjelasan teliti, baru kita respon, kita tunggu hari mesyuarat hari Jumaat. Kementerian MITI sedang meneliti dan juga koordinat dengan Washington DC dan juga kawan-kawan di ASEAN.
For more, we are joined by Admin Sim. He's a partner at Appleton Luff, an international trade and investment law firm. Admin, thank you so much for joining us. Firstly, I want to get your take on the president's pivot to Section 122. Do you see this a clever sort of workaround by him, or is it simply to buy time before the next legal challenge?
Well, thank you for having me. Yes, it's basically to buy time because Section 122 is limited to 150 days under the statute, which all these things we're talking about are sections of the Trade Act of 1930. So what's going on is that Congress years ago gave the president power to deal with balance of payment issues in the United States. This is allowed under the World Trade Organization and other agreements to deal with temporary problems with regard to the balance of trade. But that power was limited to 150 days. And so after that time, he would have to go back to Congress and seek authorization approval by both houses of Congress. And given the situation where some members of the Republican Party have openly voted against the imposition of tariffs on countries such as Canada, he might not be able to achieve the majority votes in both houses. So right now it's 150 days. We'll see how it goes after that.
Edmund, I mean, I understand what you're saying, but I'm trying to understand as well. I mean, this is a ruling from the highest court in the land. What are the legal options available to President Trump? You mentioned Congress. Unlikely as it stands to renew it, so what next?
So he has some other options. And, you know, the administration has been prepared for the possibility, which frankly, most of us in the trade bar understood to be a fairly high likelihood, that the Supreme Court would rule against the use of the International Economic Emergency Powers Act, or IEPA, which is what was struck down on Friday. So they've had time to prepare. And so the issue, which is what is the procedure under these other laws? And so you heard the president talk about other sections of the laws, like 122, which he invoked on Friday and Saturday. But you have other sections of the law, such as 232, which deals with national security issues. And so those tariffs are still in effect. Those were not subject to the court review and opinion on Friday. So so he's perfectly within his rights to go after it in that way. And so you have other sections such as 301, 201, and 338, which you also mentioned on Friday.
Okay, I have more questions about those other sections, but meantime, I'm curious about what will happen, to trade deals that many Asian countries have signed with the U.S. I mean, I guess broadly speaking, there are two categories: those like Japan, South Korea, and Taiwan, which already had rates at 15%. So essentially, you could say there's no change, but you do have others as well, like Indonesia, Malaysia, and Cambodia, which currently have 19% tariffs. So what becomes, from a legal perspective to all these agreements?
Well, from an international point of view, the agreements between those countries and the United States are still in effect. The real question is whether the administration, is going to implement that under U.S. domestic law. And so for the time being, countries that have tariff rates, that negotiate tariff rates above 15%, are currently enjoying temporarily a lower rate. And so the question is going to be, would anyone, on a diplomatic level, want to disturb the status quo? Because of the existence of these other sections of the law, he can always try to impose, or actually do impose, higher rates above the 15. So, it's a diplomatic consideration for every country, whether or not they want to revisit the agreements that they already have with the United States. I mean, I think it would be difficult, for example, for countries which just were in the United States last week for the Board of Peace meeting to then turn around and try to renegotiate or try to revisit what they already had negotiated with the U.S. administration.
I wonder what it would mean also for those stalled in disputes or haven't fully finalized trade deals like China, India, Canada, and Mexico. How would this deadline sort of reshape the negotiating dynamic? Have their bargaining positions improved?
I think the bargaining positions have changed. I wouldn't say it's been improved or degraded, because a lot of those negotiating positions were based on power-based considerations. And so the legal changes that we had on Friday, and subsequent to Friday's court ruling, haven't really changed the power dynamics. And this administration is very focused on the power dynamics between themselves, the United States, and countries such as China and the EU. So, and that's why the administration, the president, immediately wheeled out these new tariffs under 122. And so we can see them preparing for what happens after day 150.
Edmund, just want to go back to the points you were making about other sections which the Trump administration can use: Section 232, Section 301, some of which apply to sectors like steel and aluminium. So I'm wondering whether or not the Trump administration could expand the use, of these other sections to impose more tariffs, even if, even if they are everyday items, I don't know, like furniture or clothes, for example?
Yes. So we currently have 232 duties or investigations on things such as automobiles, trucks, furniture, steel, aluminum. And so these could be expanded in scope, both in terms of the existing duties. So, for example, a product, you could interpret 232 on the 232 proceeding on steel to apply to any product incorporating steel. So that would be a broader interpretation of an existing investigation and duty. You also could have new investigations of other industries. And so there is relatively little restriction of what the administration could apply these duties to in 232 or in 301. I think the difference between what we had under IEEPA, under what is termed Liberation Day duties, Liberation Day was based on a country-specific approach. And so it was broadly applied to all kinds of goods from various countries. Whereas these other statutes we're talking about, such as 201, 232, 301, 338, those are industry specific. And so the administration at the time last year, didn't want to follow the statutory requirements of giving notice and allowing for people to, comment and perhaps talk to the administration. They wanted to have a grand single stroke approach. But the drawback of that is that it was subject to the court review, and now they've had to back off. So the question is, have they prepared inside USTR and the White House the legal foundations, the factual foundations for applying these other statutes? And if they have, then we could see them beginning to roll out the other statutes beyond 122. 122 is a global approach that applies to all countries. There are some exceptions. For example, agricultural goods, some products like spices and stuff from India and such, which are not grown in the United States, are exempted. But by and large, it's a global approach for all countries. By switching to these other sections of the trade law, they're going to have more discretion, but it's going to take more time. And that's something that they really don't want. They're going to have this 150 days. And so they really don't want to have any gap between day 150 under 122 and potentially day 151 under any of these other statutes sections.
Understood, Wednam. Thank you very much for your expertise and breaking it all down for us. Edmund Sim, a partner at Appleton Love International Lawyers.